This is Syndication Attorney Field Notes. I'm Tilden Moschetti, and I'm a syndication attorney. Today's field note is about the LLC operating agreement in a Regulation D syndication. Here's the scene that keeps repeating. A sponsor sends me a deal, and the PPM is sharp. Clean numbers, good business plan. Then I ask for the operating agreement, and I get a template someone downloaded and barely touched. The question underneath is always the same. Isn't the operating agreement just LLC paperwork? That sounds simple. But the legal frame changes the moment real investor money is coming in. So let me give you the direct answer first. The operating agreement is not administrative paperwork. In a Regulation D syndication, it is the engine of the deal. It's the binding contract among the members of the LLC. It decides how money moves, who has control, what investors can vote on, and how your role as the sponsor is protected or limited. Here's the clean way to hold it in your head. When you file with the state, you create the shell. That filing just tells the state the company exists. The operating agreement decides how the shell behaves. The state creates the shell. The operating agreement runs it. Now, why do smart sponsors still get this wrong? Because of the label. A single owner LLC has an operating agreement. A $10 million apartment syndication has an operating agreement. Same two words on the cover, but they are not doing the same job. A simple LLC agreement usually just says who owns the company and splits profits pro rata. Everybody shares equally. Everybody has a say. That's fine for a corner business. A syndication needs something completely different. You have passive investors who put in capital but don't run the asset. You have a preferred return where investors get paid to a target before you share in profits. You have a sponsor promote, which rewards you after certain targets are hit. You have your fees, and you have you as the manager holding operating control. A generic template can describe an LLC. It rarely encodes a syndication. The parts look similar. The machinery underneath was never built for this. Okay, now the single most useful distinction in this whole episode, the PPM versus the operating agreement. The PPM is the brochure. Its job is to explain the deal and disclose the risks. It tells the story in plain English so an investor understands what they're getting into. The operating agreement is the engine. It takes those promises and turns them into binding rules. Where the PPM says investors will receive a preferred return, the operating agreement contains the actual language that defines how that return is calculated, when it accrues, and where it sits in the payment order. The PPM describes the machine. The operating agreement is the machine. And here's the piece sponsors miss. The operating agreement is part of the offering. It goes in the investor package. Summarizing its terms in the PPM is not a substitute for the actual contract. Let me give you a quick example because this is where it gets real. Say your PPM describes an 8% preferred return, but the operating agreement, the one that actually got signed, says 6%. Now they don't match. Generally, because the operating agreement is the binding contract, its terms control the entity math. Your accountant runs 6%, not 8%. So people assume the operating agreement wins, and that's the end of it. But don't read that as good news. A mismatch like that means your disclosure document was wrong. Your investors received materials describing a deal you never structured to pay. The point isn't who wins the math. The point is the two documents should never disagree in the first place. A conflict like that isn't a loophole. It's a drafting failure you want to catch before you raise $1. So let me tell you what not to assume. Don't assume a preferred return is a guaranteed payment. It isn't. It's a priority right tied to available cash. Investors get paid first when the money is there. It's a target, not a promise. Priority economic rights, not guarantees. Don't assume your fees are protected just because they're common. Acquisition fees, asset management fees, disposition fees. If the operating agreement doesn't authorize them in specific terms, taking them can look like a breach of your duty to the entity. Customary is not the same as contractual. And don't assume the governance terms in a downloaded template are the ones you'd actually want. Manager removal is a good example. A generic form might let investors remove you by a simple majority vote at any time over any ordinary disagreement. A carefully drafted agreement usually restricts removal to serious causes like fraud or gross negligence. Whether your investors can fire you at will or only for real misconduct is a drafting decision. The template's default is rarely the one you choose. Same with liability. The operating agreement can define or limit certain duties depending on your state of formation. But it is not an absolute shield. You cannot contract your way out of fraud or intentional misconduct. Any document that promises you that is overpromising. So here's the field note. In a Regulation D syndication, the operating agreement is your deal's operating system. The PPM is the brochure. The operating agreement is the engine. They should tell the same story from two different jobs. One discloses, one executes. The risk for a sponsor isn't having a document labeled operating agreement. Almost everyone has one. The risk is having one that doesn't run the syndication you actually sold. The longer written version with the full waterfall and governance breakdown is in the show notes. I'm Tilden Moschetti, and that's today's Field Note.